ever buy something based on, like, a promise, and then later on you find out, whoops, that promise wasn't actually in writing anywhere. So it's, like, totally unenforceable.
Yeah,
Yeah, it's a real bummer.
it happens all the time.
Well, today's deep dive is all about how to avoid exactly that kind of situation, and it all comes down to understanding this thing called the Parol Evidence rule.
Right.
And trust me, it's way more interesting than it sounds.
It really is. It's actually fascinating. The parole evidence rule is basically, it's a legal principle that says, look, if you have a final written contract,
Hmm.
a court's generally not going to consider any like prior agreements, conversations, anything like that.
Okay.
That contradicts what's in that, the actual signed document.
So it's like the ultimate get it in writing kind of rule.
Exactly. And it exists for a reason, right?
Yeah.
Written contracts, they provide clarity, they prevent misunderstandings.
Mm-hmm.
And let's be honest, those misunderstandings happen all the time.
Oh, yeah. All the
Mhm.
time.
Remember that antique stove that the seller promised, oh yeah, you're going to get this with the house.
Right.
If it's not in the contract, legally, it's not part of the deal.
Ouch. Yeah, that's got to sting.
Yeah.
So anything said or written down before the contract is signed is basically irrelevant. Like side deals, verbal promises, even emails.
Yeah.
Uh,
It doesn't even have to be just spoken words. It could be any communication outside of that signed contract. It can potentially get thrown out in court.
Mhm.
The law really favors that clear written word.
Okay, so lesson 1, always read the fine print. But it can't be always black and white, right? What about those situations where something is left out or the wording is kind of unclear?
You're right. There are exceptions. The parole evidence rule isn't about shutting down all outside information.
Okay.
It's about making sure that final agreement is honored.
Right.
So, for instance, imagine a separate agreement that's made alongside the main contract, what we call a collateral agreement.
Okay, so like a side deal that's related but not directly part of the main event.
Exactly. Think of it like this. You're signing a lease for an apartment,
Okay.
and at the same time, you and the landlord make a separate agreement about you also renting a parking spot.
Right.
That parking spot agreement is a separate deal.
Right.
That's a collateral agreement and wouldn't necessarily have to be included in the main lease agreement for it to be enforceable,
Okay.
you see.
That makes sense, yeah. So that's one exception. What about those times when the contract itself is just badly written, like the language is super ambiguous?
Yeah, that's another big one. If the language in the contract is just open to interpretation, a court might allow outside evidence to clarify what those terms were actually supposed to mean.
Because sometimes, let's be honest, those legal terms can be pretty dense. I'm sure even lawyers get confused sometimes, right?
You'd be surprised.
Really?
This is where it gets really interesting. There's this idea of a partially integrated contract,
Yeah.
where the written document might not capture the entire agreement. One of the most illustrative cases on this is Masterson v. Sign. It involved a family selling their ranch,
Okay.
but they had this verbal agreement that the ranch could only be bought back by a family member.
So a bit of a family pact, but not written into the official contract. What happened?
Well, things got a little complicated, you see, because one of the family members involved ended up in bankruptcy.
Oh, no.
Yeah.
Okay.
And the question became, could the bankruptcy trustee buy the ranch using that buyback clause,
Oh.
even though there was this separate, family agreement?
I'm guessing the family was not too happy about that.
You could say that. But in this case, actually, the court sided with the family.
Really?
They felt that this verbal agreement, this idea of keeping the ranch within the family, it was like a key part of the deal, even though it wasn't, explicitly spelled out in that written contract.
Wow.
This whole idea of a partially integrated contract.
Okay.
It highlights that sometimes that written document, it doesn't capture the entire agreement, and context really matters.
That's really interesting. So even if it's not on paper, the court kind of recognized the spirit of the agreement.
Right.
But I imagine that's not always the case, right?
You're absolutely right. Relying on those verbal agreements, it can be risky.
Right.
And this case was, very specific circumstances. It's a good reminder that while the parole evidence rule aims for that clarity, there are nuances. Courts have some wiggle room to consider context.
So what you're saying is don't bet the farm on a handshake deal.
Pretty much.
Okay.
Speaking of nuance, there's another piece of this puzzle we should probably discuss, and that is the Uniform Commercial Code, or UCC for short.
Ah, yes. The UCC sounds a bit intimidating, if I'm being honest.
I promise, it's not as scary as it sounds.
Yeah.
Think of the UCC as a set of rules specifically designed to kind of bring some flexibility into business transactions.
Okay.
And when it comes to the parole evidence rule, the UCC is a bit more relaxed than, common law.
Okay, so less lawyer speak, more let's make a deal. I like it. How does that flexibility actually play out in the real world?
So the UCC recognizes that
Right.
business contracts, they might not always be totally, complete on paper.
Right.
It assumes there might be important details or understandings based on things like, past dealings, industry standards.
Mm-hmm.
For example, imagine you have an ongoing relationship with a supplier,
Yeah.
right? And you've always done business a certain way.
So there's already this unspoken understanding based on your history.
Exactly. The UCC allows for that kind of context to be considered, even if it's not explicitly written into every single contract.
So it's acknowledging that business, especially between people who know each other, doesn't always happen with, this formal contract signing for every single interaction. There's a history, there's a relationship.
Absolutely. And that history can be crucial in understanding the true intentions of a contract.
Right.
But don't get any ideas. This does not mean you can just ignore written contracts in the business world.
Right, of course.
It's all about striking that balance.
Right, it's not a free-for-all.
Right.
But I can see how that flexibility would be really important in the fast-paced business world. So we've talked about side agreements, ambiguous language, even these unspoken understandings. What happens when, even with the best of intentions, the words themselves are the sticking point?
Yeah, you're talking about those situations where even a single word can make or break a contract.
Right.
Take, for example, the infamous chicken case.
Okay, now you have to tell me more about this chicken case. It's not every day you get to say that phrase.
It really is the case that keeps on giving. Back in 1960, a company called Frigliment Importing ordered a whole bunch of chicken from B&S International Sales. Seems simple enough, right?
Chicken is chicken, or so you'd think. What went wrong?
Well, when the shipment arrived,
Yeah.
Frigliment claimed that the chickens weren't the kind they were expecting.
Oh, okay.
They were older, tougher birds, more suitable for, stewing than, say, grilling up for a barbecue.
Ah, so a case of fowl. Play with the word chicken.
You got it. It all boiled down to what that one word, chicken, really meant in the context of the contract.
Okay.
The contract was even written in German, which added a whole other layer of complexity.
This just keeps getting better and better. So did the court bring in a panel of chefs to weigh in on what constitutes a proper grilling chicken?
Not quite. What they did do was they used an objective standard to define chicken, meaning not what either party thought it meant, but what a reasonable person would understand it to mean. They looked at things like dictionary definitions, how the word was used in the industry, even the price of the chickens.
So context is everything. What was the final verdict?
The court ultimately sided with the seller because the broader definition of chicken included those older birds.
Okay.
Frigliment was probably wishing they had specified the age and type of chicken a bit more clearly.
That's a tough break for Frigliment, but a good reminder for all of us that even seemingly simple words can have multiple interpretations.
Absolutely, and this case highlights something else really important, this idea of who bears the burden of proof when a contract term is unclear.
Meaning, who has to convince the court that their interpretation is the right one?
Exactly.
So in this case, Frigliment had to prove that their very specific definition of chicken was what both parties understood at the time of the agreement.
You got it. Because they were the ones claiming a narrower, more specific definition of chicken, the burden of proof fell on them. And when it comes to interpreting these ambiguous terms, courts generally lean toward that objective plain meaning unless there's strong evidence to suggest otherwise.
So when in doubt, spell it out. Sounds like a good rule of thumb to me.
You said it. Clear and precise language is your best friend when it comes to contracts. But before we get too comfortable, there's another case I think you'll find fascinating. This time, the word in question was flood.
Okay, flood. That doesn't sound nearly as exciting as chicken, but I'm intrigued. Lay it on me.
This case, in Ray Katrina Canal breaches litigation, stemmed from the devastating aftermath of Hurricane Katrina.
Oh, wow. That's a lot of weight for one little word to carry.
You can say that again. The case involved numerous property owners who suffered damages from the flooding after Hurricane Katrina.
Right.
Many of them had insurance policies, but the insurance companies were denying coverage, claiming that the policies specifically excluded flood damage.
Okay, this is where the definition of flood becomes very, very important.
Exactly. The property owners argued that the word flood was ambiguous in their policies.
Okay.
They claimed it could be interpreted to mean like a natural disaster or a man-made disaster, like, the failure of the levees,
Hmm.
which is what exacerbated the flooding in New Orleans.
Right.
They were essentially arguing this wasn't just any old flood, this was a failure of infrastructure, which should be covered.
That makes sense. So what did the court say? Did they allow for a more nuanced interpretation of flood given the circumstances?
Unfortunately for the homeowners, the court kind of went with the plain meaning of the word flood. They sided with the insurance companies, ruling that the word didn't distinguish between floods of, different origins. It
Right.
was a tough break for the property owners
Yeah.
and a stark reminder that courts often favor that, objective dictionary definition unless there's really strong evidence to do otherwise.
Wow. So even in a situation like that, where there were these broader issues at play, the court really just stuck to that literal meaning of the word. It really highlights how crucial those definitions are.
Absolutely. And this case also brings up a doctrine you might find interesting, the contra proferentum doctrine.
Okay, now that's a mouthful. Break it down for me.
Dory, it's actually a pretty straightforward concept. It basically says that, look, if a term in a contract is ambiguous, the court will usually interpret it against the party who drafted the contract.
So the one who chose the words might end up stuck with the worst interpretation? That seems fair.
Exactly. It incentivizes that clarity,
Right.
that fairness
Yeah.
in drafting these contracts. You don't want to give anyone the benefit of the doubt if their wording is sloppy.
Right.
In the Katrina case, even though the insurance companies, they wrote the policies, the court didn't find that the word flood was ambiguous enough to apply that doctrine.
So another point for Team Clear Language. It's like they say, the contract is only as good as the words on the page.
Couldn't agree more.
Yeah.
But even with all these, rules and doctrines, at the end of the day, contracts are still made between people.
Yeah.
And relationships, they can complicate matters.
So true. What are some key takeaways for our listeners? What do we really need to remember about this whole parole evidence rule thing?
For starters, always, always, always get it in writing. It seems obvious, but you'd be amazed how many disputes could be avoided with a, clear, well-drafted contract.
Mm.
Remember, a court's goal isn't to rewrite your agreement. It's to try to figure out what you actually agreed to at the time.
Right, so clarity is key. And if something seems ambiguous, don't be afraid to ask for clarification. Better to iron out those wrinkles before you sign on the dotted line.
Exactly. Don't be afraid to ask questions. Make sure everyone is truly on the same page. Once that ink is dry, it can be a lot harder to, untangle those misunderstandings.
This has been such an eye-opening deep dive. I'm looking at contracts in a whole new light now.
I'm glad to hear that. The parole evidence rule, you might seem like a dry topic, but as you can see, it's full of these twists and turns and, real-world applications.
Absolutely. Any final words of wisdom for our listeners? What's the one thing you hope they take away from our conversation today?
Even with a, rock-solid contract, context and relationships still matter. A contract, it's a tool, but it's how we use that tool and how we treat each other throughout that process that, ultimately determines the outcome.
Beautifully said. It's a good reminder that even in the legal world, that human element is essential.
Couldn't have said it better myself. It's all about finding that balance
Yeah.
between the clarity, the flexibility, protecting your interests, but also building, strong, trustworthy relationships.
Wise words to navigate the wild world of contracts. And on that note, we'll wrap up this deep dive. But as always, keep those minds sharp, and we'll catch you next time for another fascinating exploration.